What you're about to watch will change how you see legal conflict forever. This is the Strategic Brief. The psychology of high conflict litigation. Why smart people lose control in court, and what the most effective participants do differently. Most people enter litigation believing it is about legal arguments, evidence, documents, court procedure. But experienced observers eventually discover something else. In high conflict disputes, the decisive factor is often psychology. And once you understand the pattern, you begin to see it everywhere. Across disputes involving founders, investors, and business partners, the same phenomenon repeats itself. Highly intelligent people make catastrophic decisions. Professionals with decades of experience suddenly behave irrationally, and disputes that could have ended quickly spiral into years of conflict. Not because the law is complex, but because human behavior under pressure follows predictable patterns. And there is one psychological force in particular that quietly destroys more litigation strategies than almost anything else. We will come back to that shortly. Before we examine that force, it is worth understanding why litigation is so psychologically different from other forms of conflict. In most disagreements, the parties are free to walk away. They can disengage. They can change their mind. They can simply stop responding. Litigation removes that freedom. Once proceedings begin, the parties are locked into a formal structure. Every step is documented. Every response is required. Every silence can be interpreted. This structural constraint amplifies everything. Emotions that might otherwise dissipate are instead compressed and concentrated. And the longer the dispute continues, the more those emotions define the behavior of the participants. There is also the question of information asymmetry. In litigation, both parties are operating with incomplete information about the other side's position. Neither party knows precisely how strong the other's case is. Neither party knows what evidence the other has gathered. Neither party knows how much the other is willing to spend or endure. That uncertainty creates fertile ground for psychological manipulation. Experienced participants understand that projecting confidence, even when privately uncertain, can shift the psychology of a dispute significantly. The appearance of strength, consistently maintained, forces the opposing party to make conservative assumptions about their own position. This channel examines disputes from a strategic perspective. But before we examine the channel's approach, it is worth pausing on a question that many viewers of this content eventually ask. If psychological dynamics are so predictable, why do so many intelligent, experienced professionals still fall into these patterns? The answer is straightforward. Knowing about a psychological dynamic and resisting it under pressure are entirely different skills. Most people have some intellectual awareness that they become less rational when stressed. But that awareness rarely translates into behavioral change in the moment. Because the psychological forces at work in litigation, ego, fear, identity, are not subtle. They are intense, and they operate on deeply ingrained instincts that evolved long before legal proceedings existed. Resisting them requires deliberate practice, ongoing support from advisors who understand the dynamics, and often a structural framework that creates distance between emotional impulse and formal action. Litigation functions as an emotional amplifier. Every disagreement becomes documented. Every conversation becomes evidence. Every misunderstanding becomes an allegation. Something subtle then occurs. The dispute stops being about the original issue, a contract, a payment, a shareholder disagreement. Instead, the conflict becomes about something much deeper: reputation, validation, justice. Once a dispute becomes about identity rather than outcome, rational decision-making begins to deteriorate, and that is where strategic mistakes begin to appear. Most litigation errors are psychological in origin. They do not begin in the courtroom. They begin in the moments when emotion overrides judgment, when pride overrides strategy, when the desire to be right overwhelms the need to make good decisions. Understanding how these errors occur is the first step toward avoiding them. There is a concept that experienced observers sometimes call the identity trap. It occurs when a participant begins to define themselves by the outcome of the dispute. Winning is no longer simply a strategic objective. It becomes a statement about who they are, their competence, their integrity, their worth. Once that shift occurs, the psychological cost of compromise becomes unbearable, because compromise no longer feels like a negotiated outcome. It feels like a statement of personal failure. Recognizing the identity trap in yourself and in your opponents is one of the most valuable skills in high-conflict litigation. High-conflict disputes usually follow a predictable escalation pattern. First comes the triggering event, a disagreement, a contract breakdown, a financial dispute. Then comes the first legal move. A letter, a demand, an application. That action triggers a reaction, often emotional. The other side responds. The first side escalates again. Very quickly, the dispute enters a cycle. Each step becomes psychologically harder to reverse. Compromise begins to feel like defeat. Positions harden. Costs increase, and the dispute begins to operate on momentum rather than strategy. The escalation cycle is self-reinforcing. Once it begins, breaking out of it requires deliberate effort. It requires one party to absorb short-term discomfort in order to create long-term strategic advantage. That is a psychologically difficult thing to do when emotions are elevated. But it is often the most important thing a participant in litigation can do. There is another dynamic that accelerates escalation cycles significantly. Advisors, lawyers, consultants, and other professionals often play a decisive role in shaping the psychology of a dispute. The most skilled advisors understand that their role is to de-escalate where possible and to pursue strategic objectives efficiently. But not all advisors operate that way. Selecting advisors who understand the psychology of conflict, not merely the law, is one of the most consequential decisions a participant can make. But escalation alone does not explain why so many disputes spiral out of control. The most destructive force in litigation is something else entirely: ego. And ego produces some of the most predictable mistakes in high-conflict disputes. Ego transforms disputes into personal battles. It encourages statements that should never be made, emails that should never be written, applications that should never be filed. Once ego takes control, something interesting happens. Opponents become predictable. They react quickly. They escalate emotionally. They reveal information unintentionally. For experienced observers, this behavior becomes visible very quickly, because emotional participants often create their own strategic problems. Meanwhile, the most effective actors in disputes do something different. They remain calm. They observe patterns. They respond deliberately. The absence of ego does not mean the absence of determination. Effective participants in litigation can be highly motivated and strategically aggressive, but that aggression is directed by analysis rather than emotion. It is controlled, it is calculated, and it is far more effective. Ego-driven behavior in litigation tends to produce one very specific outcome. The other side receives a gift. Every intemperate email, every aggressive application filed without strategic purpose, every public statement made in anger. These become weapons for the opposing party. Strategic actors collect this behavior quietly. They observe, they document, and at the right moment, they use it. There is a phrase that experienced observers sometimes use: let them exhaust themselves. Ego-driven participants expend enormous energy. They draft lengthy correspondence. They pursue tangential applications. They engage in public disputes that serve no strategic purpose. All of that activity consumes time, money, and emotional resource, and it generates a trail of evidence that a strategic opponent can use systematically. The most effective response to an ego-driven opponent is often patience, not passivity, but deliberate, disciplined patience, allowing the opponent's own behavior to become their primary liability. If ego escalates conflict, fear destabilizes judgment. Litigation introduces uncertainty, uncertain costs, uncertain timelines, uncertain outcomes. For business owners and professionals, this pressure becomes psychologically exhausting. Cash flow tightens, sleep disappears, every email feels threatening. Under those conditions, many participants make decisions designed simply to stop the pressure, not decisions designed to achieve the best strategic outcome. In high-conflict litigation, endurance often matters more than aggression. The participant who can maintain clarity under sustained pressure holds a structural advantage. Fear also manifests in premature settlement. Participants accept outcomes far below their actual position simply to end the psychological discomfort. This is one of the most common and costly errors in litigation. The decision to settle should be made strategically, based on an objective assessment of risk and outcome, not emotionally, based on the desire to escape discomfort. Managing fear in litigation requires building what might be called a psychological infrastructure. This means having clear, consistent communication with your advisors. It means understanding the realistic range of outcomes before proceedings begin, not discovering them mid-dispute when pressure is highest. Consider a hypothetical example. Two founders fall into dispute over the control of a company. Initially, the disagreement is manageable. But legal correspondence begins. Accusations escalate. Applications are filed. One founder becomes angry. The other becomes fearful. The angry founder escalates aggressively. The fearful founder reacts defensively. Emails begin flying late at night. Statements are made publicly. Positions harden. Months later, the dispute is no longer about the original issue. It has become about victory, control, reputation. At that stage, strategic clarity has usually disappeared, and the conflict becomes far more destructive than the underlying disagreement ever was. What is important to observe in that hypothetical is not merely the escalation. It is the predictability of the escalation. Every move followed logically from the psychological state of the participants. The angry founder behaved exactly as an angry person behaves. The fearful founder behaved exactly as a fearful person behaves. Neither was acting strategically. Both were acting psychologically, and both were making the dispute more difficult and more expensive to resolve. Now, consider what the hypothetical would have looked like if one of those founders had been operating strategically. They would have responded to correspondence slowly and deliberately, not within minutes of receiving it, not at midnight. They would have communicated through their advisors rather than directly. They would have avoided making public statements. They would have focused exclusively on the legal and commercial objectives, not on winning the narrative battle on social media or in industry circles. And they would have recognized very early that the dispute had entered an escalation cycle and deliberately chosen not to feed it. That choice alone, the choice not to escalate, often represents the single most valuable decision available to a participant in high-conflict litigation. It is a decision that is extraordinarily difficult to make when emotions are elevated, but it is a decision that defines the entire trajectory of a dispute. The most effective participants in litigation share a rare quality: detachment. They do not ignore the conflict, but they refuse to become psychologically consumed by it. They observe behavioral patterns. They analyze leverage. They manage information carefully, and they avoid reacting impulsively. In high-conflict disputes, this difference between reaction and strategy can be decisive. Detachment is not passivity. Strategic detachment means engaging with the dispute on your own terms, in your own time, in a manner that serves your actual objectives. It means resisting the psychological pull to respond to every provocation. It means understanding that silence is often more powerful than escalation. And it means keeping the end goal in clear view even when the immediate pressure is intense. The path to strategic detachment is not easy. It requires discipline. It requires the ability to separate personal identity from the dispute. And it requires a clear understanding of what outcome you are actually trying to achieve. But for those who develop this capacity, it represents a substantial and durable strategic advantage. Strategic detachment also changes how opponents perceive you. An opponent who cannot provoke a reaction begins to lose confidence. Their escalation produces no visible result. Their provocations go unanswered. Their public statements generate no response. Over time, this has a destabilizing effect. The opponent begins to question their own strategy. They escalate further, often making increasingly poor decisions in an attempt to provoke a reaction. And in doing so, they create exactly the vulnerabilities that a strategic participant can exploit. This is why detachment is not simply a defensive quality. In the right circumstances, it is one of the most powerful offensive tools available. There is one final dimension of litigation psychology that deserves specific attention: the role of narrative. Every dispute has a factual record, documents, correspondence, financial data. But alongside that factual record, every participant constructs a narrative, a story about what happened, why it happened, and who is responsible. Those narratives are not neutral. They are shaped by ego, by fear, by identity. And once a narrative becomes fixed in a participant's mind, contradictory evidence is systematically discounted. This is what psychologists call confirmation bias. And in litigation, it operates with particular force. Because the stakes are high, the stress is intense, and the human need for a coherent story is powerful. The most effective participants in litigation understand this about themselves. They actively seek out advisors who will challenge their narrative, not reinforce it. They treat their own account of events as a hypothesis to be tested, not a truth to be defended. Very few people analyze disputes at this structural level, but those who do begin to recognize patterns that others miss. This channel exists for people who want to understand conflict strategically. Power, procedure, psychology. If that perspective interests you, consider subscribing. because the dynamics become clearer with each analysis. If you are currently facing a high-conflict legal or commercial dispute and would like strategic perspective on the structure of the situation, you may contact the channel at thestrategicbrief71@gmail.com. Any discussion would be general strategic commentary only and not legal advice. Understanding the psychology of litigation does not eliminate conflict, but it allows you to see the structure of the conflict more clearly. And clarity is often the first step toward control.